Hello and good morning friends, welcome to the CEC-UGC live lecture. Dear friends, as you know that we are going on with our current series on general course on intellectual property. So far we have conducted numerous sessions under this very series, and I would like to tell you all, since our previous two lectures we have been talking on patentable subject matter in India. As I said, we have conducted two lectures in this particular topic, and today also we are going to talk on this particular topic, that is patentable subject matter in India. And for this we have again with us in our studios Mr. Ashwini Sewal. Mr. Sewal is Assistant Professor in Faculty of Law, University of Delhi. I would like to tell you all that he is the course coordinator of this particular series, that is General Course on Intellectual Property. So I believe that he is the right person to talk on this particular series, the particular topic. And dear friends, I would like to tell you all, he frequently participates in various conferences, seminars and workshops. There he shares knowledge, exchange knowledge. So he is the right person to talk to on this particular topic. So without wasting any time, I would like to welcome our guest, Mr. Ashwini Sewal. Mr. Sewal, welcome to the Edison
Thank you
lecture.
very much. Good morning, viewers. See, we, as Gitika rightly mentioned, is right now running a series of lectures titled General Course on Intellectual Property, and the present topic that I am discussing from last two lectures is the patentable subject matter in India. Viewers, if you remember, in my previous discourse I dealt with section 3 of the Indian Patents Act 1970, wherein we categorized section 3 of the Patents Act India into 4 subheads, into 4 parts. I'm gonna revise few points in 5 minutes time to make you recall those important categories that we made of section 3 to threadbarely analyze section 3 of the Patents Act 1970. Apart from that, if you remember friends, we had the threadbare analysis of various provisions of section 3, especially till section 3 subsection D. We have covered the threadbare analysis of the provisions of the language and its sweep of the Indian Patents Act 1970. Let me take you to the categorization which we were discussing in my previous discourse. Friends, if you remember, I bifurcated the section 3 of the Patents Act India into 4 parts, major 4 parts. The first one, which talks about or which comprises works which are less than an invention, which cannot be given a patent protection because they comes under the category which are called less than an invention. The second category that we made and that we basically segregated within the section 3 of the Patents Act India, that is works which are mere discovery but not inventions. As they will remain mere discovery, they cannot be given a patent protection. The third category under this categorization is the category which comprises the works which are protectable by other intellectual properties, not by the Patents Act. It means it may be given a copyright protection, it may be given a other kind of a intellectual property protection, but not a patent protection at all. And the fourth category that comes in the last is the category which says works which are inventions but not inventions for the purposes of obtaining the patent. These are the 4 categories that we bifurcated in our previous discourse, if you recall it properly. And this categorization was primarily done for the purpose of making the interpretation of section 3 convenient to the readers of section 3 and to the viewers right now. And this categorization makes this lengthy section very easy to read and very easy to discern and comprehend. Friends, this section 3, if you see the composition of this section 3, consists many clauses in it, comprises many clauses, many subsections in it. And these subsections are primarily the works which cannot be given a patent protection. As everybody knows, I presume it, those who are following me from my previous lectures, I presume that they must be knowing that section 3 is a section which is negatively worded section, excludes many works under its ambit, not to give the patent protection to those works which are mentioned enumerated under section 3. Those works can never be given a patent protection because they have been expressly excluded by purview of section 3. So with this presumption that viewers are following me and we are on the same pages, I did the categorization of section 3 in my previous discourse, wherein I bifurcated into the 4 heads. Now in today's discourse, my entire discussion would revolve on a very important point, or say would revolve on bringing several clauses into these respective 4 categories of this categorization we have just made, or we have just did in the previous discourse, in the previous lecture. There are several clauses of section 3. One by one we will pick the clauses mentioned under section 3, and viewers, these clauses are basically the works, they are basically works over which a patent can be sought, over which a patent protection can be granted. But as I mentioned, section 3 excludes these works to be given a patent protection. There can never lie a patent protection, or there cannot get conferred any patent protection on these kinds of works, and their exclusion is premised on one or the other reason. We will see the reason, the premise of the exclusion of various works apart from bringing or falling squarely all these works mentioned under section 3 into different categories shown by me in the previous slide. These are the 4 categories under which we will pick one by one all the works mentioned under section 3. Viewers, I would like to mention here that under these 4 categories, works can be brought squarely, can be bring squarely, but the point is there are certain works under section 3 which may fall into 2 categories, which may fall into 3 categories, which may fall into 4 categories. So for a note of caution, you should keep in mind that one work which is falling under one category may fall into another category, may fall into next category. So kindly take care of this point whenever we will read this section 3 and we will do this categorization, abide by this categorization. We will have to take in mind that one work can be brought under 2-3 categories simultaneously, or for that matter only in one category at a time. Let us see the composition of section 3. If you have a look at this slide, these are the following inventions within the meaning of this act which are not inventions and cannot be given patent protection. Section 3 is worded in this manner. There are clauses, section 3A, section 3B, C, then D, the explanation attached to 3D, then there is another provision 3E, F, G, H, I, till you see section 3P. So it's a long, lengthy section, a very beautifully worded section excluding many things, and the premise of the exclusion is based on some or the other belief, some or the other rationale and the logic. So today we will identify what is the logic of exclusion of each and every work here, and we will take out certain examples to understand and comprehend what work is excluded by purview of section 3, by what reason or because of what reason. Friends, let us see the first category. This is the first category of our categorization, works which are less than invention. If you see section 3, as I just mentioned that there are many clauses under section 3. The first category which reads works which are less than invention. First of all, section 3A can be brought under this category. 3A reads an invention which is frivolous. Friends, an invention which is frivolous, something which is not of significance, something which is not important, something which is trivial, something which is very petty, cannot be given a patent protection. So section 3A can be brought under the first category, which says works which are less than invention. Undoubtedly, a person coming up with an invention which the patent law says a frivolous invention, it is a work, but the point is, as it is a frivolous work, it is a useless work, it cannot be given a patent protection, it is a frivolous invention, it is void of any kind of a significance and importance, it cannot be given a patent protection. So the first work, which is called a work in the form of a frivolous invention, is excluded on the logic that law does not take care of trivial things, law does not pay any heed to the trivial things. That is why a frivolous invention cannot be given a patent protection, and because of this reason it is a non-patentable subject matter, as it has been expressly excluded by purview of section 3 of the Patents Act 1970. Another clause that can be brought under the first category is 3E, which reads, a substance obtained by a mere admixture resulting only in the aggregation of the properties of the components thereof, or a process for producing such substance. Viewers, this clause 3E excludes two kinds of things. One, the substance obtained by a mere admixture resulting into aggregation of the properties of the components thereof. Another thing that it excludes is the process for producing such substance is also excluded by purview of this clause. It says that a substance which by a mere admixture results into the aggregation of the properties, the inventor is doing what? If you exemplify this clause, the inventor here, or the person who is applying for the patent protection, the applicant, he is just administering two components, and then that admixture, that act of the applicant results into mere aggregation of the properties of those already existing components. For example, if I mix hydrogen and water, that results into hydrogen and oxygen, that results into water. See, this is what? This is a admixture done by the person of the components which are already existing components known to everyone, and this mere admixture, mere, the word mere is used prefixed with the word admixture, mere admixture, only admixture will not result into a work which will rise to the merit of getting the patent protection. So the logic of excluding this work from the purview of patentability is simple, is based on the common sense, that is, that one who is just mixing two things, two components, and the resultant of those two components is the resultant of their addition thereof, that will not qualify for the patent protection. This is the logic, as anybody knowing this kind of a thing, knowing this kind of a mixing, can come out with the same thing. There is no purpose of granting a patent to that thing. Otherwise also it will get hit by the non-obviousness criteria, which we call, it would lack the inventive step in it, and it will not be given a patent protection. The third thing that can be squarely brought under this category, or the third work, is in the form of section 3F, which says mere arrangement or rearrangement or duplication of known devices. It says that mere arrangement or rearrangement or duplication of known devices, each functioning independently of one another in a known way. Friends, if somebody mere arranges few things, or if somebody mere duplicates few things, if he rearranges those things, that would not be given a patent protection, as it has been expressly excluded by purview of section 3, and according to our categorization, it may be called a work, it may rise to the merit of calling a work, but that work is less than an invention, cannot be given a patent protection. it must rise to the merit of obtaining the patent protection by proving, first of all, that it is not expressly excluded by purview of Patents Act, second, by proving the novelty, by proving non-obviousness, by proving its utility. But as it is expressly excluded, and this exclusion is premised on a simple reason that any person who is skilled in that kind of art can easily arrange things, can easily rearrange things, can easily duplicate things. And that kind of a rearrangement, arrangement or duplication of known devices which functions independently of another in a known way. If it does not function in a known way, then it may be given a patent protection. But if that arrangement, rearrangement or duplication of known devices results into functioning into a known way which is known to the people, then that cannot be given a patent protection. The another thing that can be brought squarely under this category, under the first category, which is a category I call works less than an invention, is plants and animals in whole or any part thereof. Friends, the plants and animals are excluded from the purview of giving a patent protection. There cannot be given a patent on the plants and animals in whole or on the part of the plant and animal separately. And the premise of exclusion is simple, that it is a work which is less than invention, it does not rise to the merit of giving a patent protection. Moreover, plants and animals cannot be monopolized by one single individual because they benefit the society, they are for the benefit of the society at large. One individual cannot claim, or one individual can never own one plant or its exclusive right to grow that plant, exclusive right to nurture that plant. That cannot be given to one single individual. It is like an oxygen available to everybody and does not belong to one individual. It is for all. Another category that can be brought under this first, another clause that can be brought under this first category is the mathematical or business method or a computer program per se or algorithms. Friends, a mathematical or a business method or a computer program per se or algorithms, these are the works which are less than invention. They cannot be given a patent protection as they are expressly excluded from the purview of obtaining a patent protection. If you have a look at this clause, it reads mathematical or business method. It excludes three things. It excludes any mathematical thing, any mathematical formula, any mathematical equation. It excludes business method. It excludes computer programs per se. So three things are excluded by purview of this particular clause. When we talk about business method, friends, I would like to make you aware that in US, business methods are patentable, but in India, business methods cannot be given a patent protection as they are expressly excluded from the purview of giving a patent protection by Section 3 of the Patents Act 1970. In India, business methods can be given a patent, can be protected not as a patent but as a trade secret or something like that. But patentability of business method is impossible in India, but in United States it is possible. The third thing that this clause excludes to be given a patent protection is computer programs per se. Friends, if you have a look at the language, it reads computer programs per se. Computer programs per se. The word per se is attached with the word computer program. So this clause excludes computer programs per se to be given a patent protection, but by using the word per se, it reads or it seems that some sort of computer programming can be given a patent protection, except that computer program which is a computer program per se. What do I mean? That the computer program which is exclusively a computer program, which is per se apparently a computer program, cannot be given a patent protection. But if some kind of a computer program is being used in any process, if computer program is used in many of the stages of the one process and its outcome, that is a product, then in totality the entire process involving one step in the form of a computer program may be given a patent protection. But per se a computer program has been excluded to be given a patent as the language suggests. But in India no such instance can be found where a person has obtained a patent protection on a computer program, notwithstanding that there remains many computer programs involved at stages of various kinds of processes and products. Because in India computer programs are copyrightable, they are given a copyright protection by purview of section 13 of the Copyright Act 1957, wherein computer program falls under the literary work as read by many judgments or many courts in our country. Another thing that has been excluded by purview of this section is algorithms. So algorithm mathematical formulas are not patentable, they cannot be given a patent protection, they cannot be granted a monopoly to one individual, as they are necessary tools for evolving further things, for evolving science, for evolving further beneficial things for the society. They have been kept out of the scope of obtaining a patent protection by their express and explicit exclusion from section 3. Another thing that can be brought under section 3 is mere scheme or rule or method of performing mental act or method of playing game. It's a mere scheme or rule or method of performing mental act. It excludes three things again. It says, it reads that a mere scheme is not patentable, a rule or method of performing mental act is not patentable, and method of playing game is not patentable. Friends, if we would like to exemplify it, we can have lot of examples to cite here. Suppose I come up with a scheme where I invite bidders to bid and they win that particular bid. That scheme is not patentable. Then it says a mere method of performing mental act. Suppose I am a magician. I apply certain methods while performing that mental act. That is not patentable, excluded by purview of the Patents Act expressly. Again, method of playing a game. Somebody plays football and he has got a very unique technique of playing the football. Or say a player plays cricket and has got a very good unique technique of playing cricket. Or a bowler in a cricket plays that particular game with a unique technique to bowl, cannot be given a patent protection on that unique technique. That and the reason for that exclusion is quite simple, that these are the things which should be kept open to be used by everybody, and this exclusion is a very logical one and very beneficial for the society. So method of playing the game, method of performing a mental act, and a mere scheme is not patentable at all, as expressly excluded by purview of section 3 of the Patents Act, and it is also called a work which is less than an invention as per our categorization. Another category, another thing is the presentation of information. Another work that comes under this category is a presentation of an information. A presentation of an information is a work less than an invention. You can take an example of me. I am presenting here in front of you, giving you certain information about the patent law in India, about intellectual property and the regime relating to intellectual property. This presentation is a work, but this work is less than invention it cannot be given a patent protection. Friends, I would like to tell you here that this work, which is called a work in the form of a presentation of an information, is copyrightable also. It can be given a copyright protection, but it cannot be given a patent protection, because in the case of the copyright, the performance, the presentation, if structured, if fixed, having a concrete fixed form, it can be given a copyright protection. That we will discuss later when we will deal with the another category, that is the category called works which fall or which can be given a protection under other intellectual properties but not under the Patents Act. So our first category, which is called a category works which are less than an invention, it scarcely consists many clauses of section 3, and the premise of the exclusion under this category is first of all that these are the following works which are less than invention, and their other reasons for the exclusion have been explained by me just now while dealing with these clauses. Let us jump to the another categorization, that is works which are mere discovery and not invention. That is the second categorization that we did, and under section 3 there are many clauses which can fall under this categorization, which reads works which are mere discovery and not invention. Friends, as this category and its name may be suggesting that something which is mere discovery, something which is not an invention, and mere discovery means what? Something which is existing already, known but have not been discovered, or which lies, whose existence is there but have not been discovered, have not been taken out, have not been carved out. In the case of the invention, the inventor comes up with the thing for the first time, but in the case of the discovery, the discoverer just discovers it, because something which is naturally existing or as it lies in the nature, the discovery of that particular thing should not be given a patent protection. If I discover oxygen, I cannot be given a patent protection, undoubtedly, but somebody comes up with a unique thing which has never lied, have never existed in the nature, has never existed and known before, that may fetch the patent protection, because that would rise to the merit of calling a invention, not a discovery. Let us see what works are there to be brought under this category. Clause C of section 3, which reads the mere discovery of a scientific principle or the formulation of an abstract theory or discovery of any living thing or non-living substance occurring in nature. Friends, it reads that the mere discovery of a scientific principle or the formulation of an abstract theory. It excludes three things: discovery of a scientific principle, formulation of an abstract theory, or discovery of any living thing or a non-living substance occurring in nature. Let us exemplify it. What if I discover an animal which exists? Can I be given a patent protection? The answer is no, because it is a mere discovery of a living thing in the nature, or mere discovery of a non-living substance occurring in nature. That is also excluded. Mere discovery of an abstract theory is excluded from the purview of the patentability. Mere discovery of a scientific principle is excluded from the purview of patentability. And the reason of the exclusion of these two things, scientific theory and the abstract theory, scientific principle and the abstract theory, is quite simple, that the scientific principles are to be used by everybody so that the progress in the society will keep on moving, and there should not come any stop or full stop to the progress and development in the society. Scientific principles are left open to be used by everybody because they are for the benefit of the society. So some of the exclusions under section 3 are premised on the societal welfare, on the societal benefit, and some are premised on some other reasons. Another thing, another work which can be brought under this category is the mere discovery of a new form of a known substance. So it is again a mere discovery and not an invention. The word mere and the word discovery is making it very clear that something which is only a discovery, something which is not an invention, something which has already existed, something which is known, something which is a known substance occurring in nature or a non-living substance occurring in nature should not be given a patent protection. If you see section 3D, which has been a matter and topic of debate for almost 2 decades in India, as discussed by me in my previous discourse, that section 3D and its validity and its constitutional validity was challenged by one Swiss pharmaceutical company, that is Novartis, before the Madras High Court, and then later on the matter reached to the Supreme Court, wherein Supreme Court turned down all the pleas of this Swiss pharmaceutical giant, that is Novartis, on their claim of obtaining a patent protection on Gleevec. Gleevec is a drug to treat leukemia, a blood cancer, wherein the Novartis Swiss pharmaceutical giant was asking for a patent protection in India over this drug by claiming that their work in the form of this drug is a new form of the known substance and it shows efficacy over the already existing substances. In this context, they were claiming that their drug possesses therapeutic efficacy. If you read section 3D, it excludes mere discovery of a new form of a known substance, which does not result in the enhancement of the known efficacy of that substance. So something which is a mere discovery of a new form of a known substance, that is not patentable. But if that thing results in the enhancement of the known efficacy of that substance, then that may be given a patent protection. This is what was contested by Novartis in their matter relating to Gleevec, wherein they contested that the beta crystalline form of the known substance is resulting into enhancement of the known efficacy of this substance. But the court turned it down, saying that the present claim does not establish that it is resulting into enhancement of the known efficacy of the known substance, and in that context the therapeutic efficacy has to be seen. So the court rejected their plea and turned it down, saying that their work is a new form of the known substance lacking the enhancement in the efficacy of that particular substance. Had they been able to prove enhancement in the efficacy of that known substance, of that new form of that known substance, they would have got the patent protection. But as they failed in proving the enhancement in the efficacy of that known substance, they couldn't able to fetch the patent protection. What I said, I'll repeat it again, viewers. Had they been able to prove enhancement in the efficacy of that new form of that known substance, they would have got the patent protection. But as they failed in proving the enhancement in the efficacy of the known substance, they couldn't able to fetch the patent protection. So kindly keep it in mind that mere discovery of a new form of a known substance is excluded to be given a patent. But if that new form of a known substance proves efficacious or proves its enhancement in the efficacy of that known substance, in that case it can be given a patent protection. Another thing that has been excluded by purview of section 3D is mere discovery of any new property. If you have a look at this clause, in the later part of this clause, it excludes mere discovery of a new property or new use for a known substance. That is also excluded. Another part, later part of this same clause reads, mere use of a known process, machine or apparatus, unless such known process results in a new product or employs at least one new reactant. That is also excluded. But if that new use of a known process, machine or apparatus, if that results in a new product or employs at least one new reactant, in that case it may be given a patent protection. So there are certain exceptions embedded under this section 3D. If those exceptions can be qualified, can be proved by the applicant, he may get the patent protection. Otherwise, on mere discovery of a new form of a known substance, he cannot get a patent protection. On mere discovery of a new property, he cannot get a patent protection. Or on a mere discovery of a new use of a machine apparatus, he cannot get a patent protection. These are some of the things which are excluded by purview of section 3D. Another work which can be excluded or which is excluded by purview of section 3 and which can be brought under this particular clause, that is works which are works which are mere discovery but not inventions. It is an invention which in effect is traditional knowledge, or which is an aggregation or duplication of known properties of traditionally known component or components. Friends, if you look it and read it threadbarely, it reads and it excludes an invention which in effect is a traditional knowledge, or which is an aggregation or duplication of known properties of traditionally known component or components. So the word traditional knowledge has nowhere defined in the Patents Act 1970, but we can refer to the definition of the word traditional knowledge given by many organizations. For example, WIPO tried to give the meaning of the word traditional knowledge, which reads something which is based on traditional things, something, a literary work, artistic work, traditionally based literary work, artistic work, traditionally based medicinal knowledge, tradition based knowledge about healing the things, traditional knowledge about other stuff. That is called a traditional knowledge. So an invention which in effect is a traditional knowledge is excluded by purview of section 3 under section 3P, as it is a mere discovery and not an invention, so cannot be given a patent protection. Friends, I would like to draw your attention here. If you have a look at section 3P, it reads an invention which in effect is traditional knowledge, or which is an aggregation or duplication of known properties of traditionally known component or components. If you look at this section and its language, it restricts that it is restricted to an invention which in effect is traditional knowledge. Something which in effect is a traditional knowledge, or which is an aggregation of known properties of traditionally known components. Impliedly or in an implicit manner, we may read it requiring that the traditional knowledge can be given a patent protection, or an invention comprising a traditional knowledge, involving a traditional knowledge can be given a patent protection, but it must not be an invention which in effect is a traditional knowledge, or which is an aggregation or duplication of properties of traditionally known components. What does I mean to say? I would like to draw your attention here on this point, as it is very important point. It reads an invention which in effect is a traditional knowledge. What I am reading here and interpreting here from this clause is a scope of giving a patent protection to a traditional knowledge if that particular invention in effect is not a traditional knowledge, but it involves something of traditional knowledge. An invention which comprises one step of a traditional knowledge, but as such in effect is not a traditional knowledge, that may be given a patent protection, but there is no instance to quote where the court has given a patent protection, or a controller of the patent has given a patent protection to this kind of a invention which in effect is not a traditional knowledge but which involves a traditional knowledge. It is my interpretation which I propose to be taken by you, but you may refer to other readings to make your mind finally whether a traditional knowledge can be given a patent protection or not. But to me it seems, by taking an advantage of this restricted language and interpretation, we can say that something which is in effect a traditional knowledge is excluded from the purview of the patent protection, but something which is not in effect a traditional knowledge means an invention involving a traditional knowledge in it, but there are many other things consisted by that invention, consisted by that invention, that may be given a patent protection, but no instance to quote, no case law to quote where this kind of an invention comprising traditional knowledge has been given a patent protection. Friends, let us jump to the another category which reads works which are protected by other IPRs. There are several works under section 3 which are protected by other IPRs but not by patent or not by the Patents Act 1970. Let us see what are the clauses which can be brought under this category, which is a third category which we made for our convenience. Clause 3L reads a literary, dramatic, musical or artistic work or any other aesthetic creation whatsoever, including cinematograph works and television productions. Friends, these are the works which are protected by copyright law. Copyright law protects original literary, artistic, dramatic works. Copyright law protects musical work. Copyright confers a protection to cinefilms and cinematograph work, but patent cannot be granted. So the exclusion over here of these works is based on the premise and logic that they are protected by other intellectual property, that is copyright, so they are not patentable by Patents Act 1970. Another thing, topography of integrated circuits cannot be given a patent protection as it is expressly excluded by purview of the Patents Act under section 3. Moreover, this work is given a patent protection by the Semiconductor Integrated Circuits Layout Design Act 2000. There is a separate legislation conferring a protection to this work, which is a topography of integrated circuits. So it has to be given a patent protection by purview of that particular intellectual property legislation, which is Semiconductor Integrated Circuits Layout Design Act 2000, not by the Patents Act 1970. Another thing which we'll have to see when we talk about section 3 of the Indian Patents Act, works which are inventions but not for the purposes of giving a patent protection. So far we have seen 3 categories. This is the 4th category that we are going to discuss. As we have bifurcated section 3, segregated section 3 into 4 broad heads, 4 categories, and in these 4 categories several works can be brought separately respectively in those categories. We have done the allocation of 3 categories. We are jumping to the 4th and the last category, which is very important to be seen by the viewers. It's a category called works which are inventions but not inventions for the purposes of the patent protection or for the purposes of obtaining the patent. Let us see what all works can be brought under this final and the last category. Section 3B of the Patents Act reads, an invention, the primary or intended use or commercial exploitation of which could be contrary to public order or morality. Friends, if you have a look at this clause which excludes an invention, the primary or intended use or commercial exploitation of which could be contrary to public order, we have to identify what does it exclude. It excludes an invention. It is an invention. It does not say that it is a mere discovery or it is a simple work. It is an invention but not an invention for the purposes of obtaining the patent, as it has been excluded expressly. Invention which is what? Contrary to public order or morality, and the primary use of or commercial exploitation of which would be contrary to public order or morality. One thing I would like to point out here and put across to my viewers, and they must also notice it while reading this clause, that this clause by its purview and in its sweep excludes those inventions which are contrary to public order or morality. But there is a qualification, there is a rider attached which reads only those inventions would be excluded whose primary or intended use or commercial exploitation would be contrary to public order and morality. So, inventions, irrespective that they are contrary to public order and morality, can be given a patent protection if their primary or intended use or commercial exploitation is not causing any prejudice to the public order or morality. So, something whose primary or intended use or commercial exploitation is contrary to public order and morality is excluded, or an invention which is primarily to cause disturbance into the public order and morality is excluded, but any invention whose primary work and intended use or commercial exploitation is not gonna cause any public disturbance or any kind of a issue on the morality can be given a patent protection. Another thing that this particular clause in its sweep excludes from the purview of giving a patent protection is something which causes serious prejudice to human, animal or plant life or health or to the environment. Friends, there may be an invention which qualifies on all kinds of substantive requirements for obtaining the patent. Say, for example, that particular invention involves an inventive step, that particular invention is a new invention, that particular invention is having an industrial applicability, but as it is excluded by purview of section 3b, it cannot be given a patent protection, and the logic is quite simple of this kind of exclusion, that is that some invention which causes a serious prejudice to the human health, to the plant, to the animal life, to the environment, that cannot be given a patent protection. The word serious prejudice has to be considered by the viewers at utmost importance. It has to be highlighted and it has to be demarcated by the readers that only those works which are causing or which would cause serious prejudice to the animal, plant and environment are excluded, but rest of the works which are not causing serious prejudice, they may be given a patent protection. Another thing or another work which is an invention but cannot be given a patent protection or cannot be called an invention for the purposes of the patent is a method of agriculture or horticulture. That is also excluded. A method of agriculture or horticulture cannot be given a patent protection, and the logic of exclusion is quite simple, that these methods are to be used by all and does not belong to one, they belong to all, like a free air, like a oxygen, to be used, not to be monopolized, as they are for the benefit and upliftment of the society, for the societal welfare. Let's jump to few more things that can be brought under this fourth category, the last category. Any process for the medicinal, surgical, curative, prophylactic, diagnostic, therapeutic or other treatment of human beings, or any process for a similar treatment of animals to render them free of diseases or to increase their economic value or that of their products. Friends, if you have a look at this clause, it excludes processes for the medicinal, surgical, curative, therapeutic or other treatment of human beings. So, any medicinal process for the treatment of human beings, any surgical process for the treatment of human beings, any curative, diagnostic, prophylactic method process for treatment of human beings is excluded by purview of the patent, by purview of the section 3 of the Patents Act under this clause, that is 3I, and the premise and the logic of this exclusion is quite simple, that everybody would require a medical assistance, surgical assistance, treatment of human ailment. So a doctor coming up with a new process of operating a person, providing a surgery to that person, he will not be given a patent protection on that method of performing that surgery. He may come up with a unique method of performing a surgery. He may come up with a unique method of diagnosing a problem or ailment of the person, but he cannot be given a patent protection as it has been excluded expressly by the purview of section 3I of the Patents Act 1970. Another thing which is excluded, process of treatment of animals is also excluded. Not only of human beings, treatment of animals and the process related to treatment of animals is also excluded by purview of the Patents Act. Friends, another thing that we must see in this last category in our discourse is section 4. It is also a work which is an invention but not an invention for the purposes of the patent. It reads inventions relating to atomic energy, not patentable. No patent shall be granted in respect of an invention relating to atomic energy, because any patent relating to atomic energy may be very fatal for the society, may be very fatal for the defense of one particular nation, especially our nation. That is why it has been excluded by purview of section 4, not to be called a work or not to be called an invention which can be given a patent protection under section 4 of the Indian Patents Act 1970. Friends, I would like to draw your attention and put across very important point here. When we talk about this medicinal or surgical methods of treatment which are excluded by purview of the section 3 to be given a patent protection, some surgical methods, some diagnostic techniques, especially diagnostic techniques, friends, can be given a patent protection. Diagnostic techniques which are not exclusively for the purpose of treating the animal, treating the human being, they can be given a patent protection. Diagnostic techniques for the purpose of treating human beings, for the purpose of treating animals, can be given a patent protection if they are not the processes to treat human beings. What does that mean? I will exemplify it. A person suffers from an ailment, goes to a doctor, doctor diagnoses it by a process. If the doctor seeks to protect that diagnostic technique, he cannot be given a patent over that diagnostic technique. But in a case where his blood has been taken out for a investigation and a technique has been applied on that particular blood of the patient, that technique or that process is not for the treatment of the human being. That technique or that process for the diagnosis, for the investigation, is restricted to diagnosis and investigating the composition of the blood, identifying the requisite information from that blood. That may be given a patent protection, but there is no instance to quote in India where this kind of a patenting had taken place. But in many other countries, say in Japan, in US, we have many instances where diagnostic techniques, not for the treatment of human beings and animals, but techniques as such for investigating something, for investigating the blood, for investigating its composition, for investigating some other stuff, can be given a patent protection and has been given patent protection in many countries, but not in India so far. So these are several things which we have covered under section 3 which are excluded on one or the other premise. As we have seen the logics of their exclusion, as well as we have very threadbarely and elaborately discussed all the exclusions of section 3 given under section 3. So we have covered one step so far by understanding section 3 and threadbarely discerning section 3, that is, works which are expressly excluded by purview of section 3. Other things which are not falling under section 3 are patentable. Whatever does not fall, does not get covered under section 3 is patentable. Whatever is falling under its ambit is non-patentable. This is what I presume that all my viewers has understood. Further, we will see many other things relating to the patents law in India, wherein we will start in the next discourse about the procedural requirements for obtaining the patent. But before jumping to the procedural requirement, I would like to jump to other procedure, other substantive requirements for obtaining the patent, or say qualifications for obtaining the patent, that are novelty, non-obviousness and utility. That's here I rest viewers for today. Thank you very much. See you in the next lecture. Thank you.
With this note, thank you, sir. Thank you so very much. Dear friends, as we always say that we upload these lectures for you on the YouTube so that it becomes convenient for you to see these lectures the number of time you wanted. And if you too want to see this particular lecture, definitely you can watch it with the help of YouTube also. And afterwards, if you feel so that there is any query, or if you want to give your feedback regarding this particular lecture, then you can mail us at info.cc@nic.in. We would love to take your questions. We would love to take your feedback. Till then, take care. Goodbye. We would be meeting again very soon and would be talking more on general course on intellectual property laws. Till then, take care. Thank you, sir. Thank you so very much.
Thank you very much.